I'm reading out of the family law book, cases on wills, trusts, and estates. Case called Jacob v. Davis in the section of duties to inform and to account. That is on the trustees to the beneficiaries of a testamentary trust. At least probably also applies to some inter vivos trusts, but not the ones that, not usually the ones that are self-directed, where the trustee it is the settler and the settler is alive. Adkins is the justice who provided the opinion that appellant William H. Jacob Bill is the sole remainder man of two trusts established under the last will and testament of his father, Jacob John B. Jacob John. So it's a testamentary trust. Appellant sued Michael W. Davis, the surviving trustee of those trusts, and Davis's law firm, alleging numerous violations of appellee's fiduciary duties as trustees and seeking an accounting, other equitable relief, and damages. Facts is John died on January 22nd, 1994, leaving a will that created two trusts known as the marital trust and the family trust, respectively, collectively the trusts. John's surviving wife, Harriet Bell Jacob Harriet, was the income beneficiary of the trusts, and appellant was the remainder beneficiary. Another subject of Bill's complaint is the refusal of Davis to provide an accounting for the trust. Bill first requested an accounting in May of 1986 by letter to a paralegal at Alstrom and Davis, PA, who assisted Davis in estate and trust matters. Responding in a May 28, 1996 letter, May 28 letter, Davis told appellant, "Your letter raised an interesting point regarding my duties to you under the trust agreement for the aforesaid trust. As you know, I am a co-trustee with your stepmother, Harriet Bell Jacob, of this trust. Pursuant to the provisions of the trust, trustee is to render an annual account to the current income beneficiaries of the trust. At present, your stepmother is the only income beneficiary. Thus, I, as trustee, have no obligation to provide to you an accounting for the trust. If you wish, I will forward a copy of your letter to the paralegal for your stepmother for the purpose of obtaining her approval to give you an accounting for the trust. Since she and I are co-trustees, and since she is the sole income beneficiary, if I were to provide such an accounting to you without obtaining her consent first, I would be breaching my fiduciary obligations to her. Please let me know if you wish for me to do this. Your stepmother is very active in the administration of this trust and, in fact, makes all decisions regarding any distributions from the trust. My only role at this point is to facilitate her administration and to provide her any counsel that she may wish regarding the trust." After receiving this letter, appellant called Harriet to request her permission for the accounting, but she declined. Harriet died January 1997, leaving an estate valued at approximately $1.5 million. On April 17th of 1997, almost a year after her first request, appellant again requested by letter an accounting of the trust, this time through his attorneys Christopher Wheeler and Jean Lange, collectively Wheeler. In the letter, Wheeler asked that the accountings cover all assets, property, receipts, expenditures, distributions, trustee and other commissions, attorneys, and other professional fees, and any all payments or transfers to and from the two trusts and Harriet's estate. The letter also requested all books, records, tax returns, court filings, or other information concerning these items. Wheeler requested that the information be furnished by April 25th of 1997. In response to this letter, Davis wrote to Wheeler on April 18th of 1997 and said, inter alia, "Please be advised that the John B. Jacob Marital Trust was never established since the total assets that were available from the estate of John B. Jacob to be distributed to this testamentary trust did not exceed $600,000. Davis includes in this letter copies of the following documents: inventory and distribution account for John's estate, statements from the brokerage firm of Ferris Baker Watts for the family trust. Third, the letter or the check register for the family trust checking account. Fourth, 1995 and 1996 balance sheets prepared by the accountant for the family trust. Fifth, 1995 and 1996 general ledgers prepared by the accountant showing income and other deposits received, disbursements, plus sales of stocks. Sixth, income tax returns for 1995 and 1996 filed by the family trust. Seventh, a summary of profits and losses for 1995 and 1996 showing 143,543 in total distributions to Harriet over the 2-year period. And last, eighth, John's will and first and final accounting for John's estate. Davis also provided a 2-page document unsigned titled John Jacob Family Trust Recap of Transactions. The recap summarizes distributions to Harriet, but often does not designate whether they were principal or income. With respect to the other information requested by Wheeler, Davis said, with such short notice, the above is the best that we can do to comply with your request that we provide you information by April 25th, 1997. In these documents, you should be able to understand the relationship between the estate of the John B. Jacob and the John B. Jacob Family Trust and Harriet Bell Jacob. I think you will find that there were no distributions from the trust that did not comply with both the intent and provisions of the last will and testament of John B. Jacob. Davis did not provide any information information as how the expenses of the trust, such as trustees' commissions and accountant fees, were allocated between the income beneficiary and the remainderment. Furthermore, no information was provided to show how in-kind distributions of stock to Harriet were valued. Example, at inventory value or market or fair market value. Davis did offer to meet the appellant and counsel and the accountant for the estate to discuss their concerns. On May 5th of 1997, Wheeler replied that a meeting would probably be beneficial, but we would prefer that we have a little longer to digest the information you provided. In that letter, Wheeler also said, we have noted an omission in the documents you provided. As a result, we hereby request a complete accounting of all documents related to the transfer of assets owned by John B. Jacob at his death to the family trust for the period of October 1994 through January 1995. Wheeler also requested the federal estate tax return for John's estate. Davis responded to Wheeler's letter on May 7th and enclosed the Ferris Baker Watts statements for the period requested and the federal estate tax return. With respect to the statements, Appellee Davis commented, please note that there may be discrepancies between these statements and the accounting that was filed in the orphans court. The accounting does not provide a means to show changes to the prices of the equities during the time from when the estate is open until the time the estate is closed. On May 23rd, 1987, Wheeler again wrote to Davis and requested that he explain the justification for the removal of 5 stocks and 7 bonds from the trust, as well as other specific items, suggesting that these items can only be removed from the family trust pursuant to the terms and intent of the family trust established by Mr. Jacob. The record does not reflect Davis's response to this letter. Bill testified that he never received any explanation or accounting from Davis regarding the trust principal that was distributed to Harriet. Appellees took the position at trial and on appeal that they had no obligation to account to Bill. Through the letters, although the letters refer to several telephone conversations between counsel, there is no indication that the parties ever held a meeting. Appellant filed suit on July 3rd, 1997, and here's the discussion. Appellant complains that appellees never provided a full accounting of the trust created under John's will. Appellees contend that they had no obligation to provide an accounting to appellant either during the lifetime of Harriet or after her death. Alternatively, they claim that the documents they provided to appellant in April 1997 after her death were a sufficient accounting of the trusts. Appellees rely on section 10.02 of John's will, which provides, my trustees shall be excused from filing an account with any court. However, my trustee shall render an annual or more frequent account and may at any other time, including at the time of the death, resignation, or removal of a trustee, render an intermediate account of my trustee's administration to such of the then current income beneficiaries who are of sound mind and not minors at the time of such accounting. The written approval of such accounting by all of such income beneficiaries shall bind all persons then having or thereafter acquiring or claiming any interest in the trust, and shall be a complete discharge of my trustee or to my trustee with respect to all matters set forth in the account as fully and to the same extent as though the account had been judicially settled in an action or proceeding in which all persons having, acquiring, or claiming any interest were duly made parties and were duly represented. The trial court held that under the terms of the trust and applicable law, the trustees had no obligation to account to a remainder man such as appellant during the lifetime of the income beneficiary. The trial court seemingly agreed with the appellant that an accounting was due after death, but found the documents provided by appellees after Harriet's death sufficed. We do not agree with appellee's view that appellant is not entitled to request and obtain an accounting of the trusts. The leading authorities on trusts are unequivocal in their articulation of the right of the remainder beneficiary to an accounting during the lifetime of the income beneficiary and after his or her death. Austin W. Scott and William Fletcher. The laws of trust, section 172 explains. So this is the appellant disagreeing with what was just discussed, and I don't know if this is appeal or not based on the citation, but they are citing section 172 of the law of trust. A trustee is under a duty to the beneficiaries of the trust to keep clear and accurate accounts. His accounts should show what he has received and what he has expended. They should show what gains have accrued and what losses have been incurred on changes of investments. If the trust is created for beneficiaries in succession, the accounts should show what receipts and what expenditures are allocated to principal and what are allocated to income. Restatement second of trusts, section 172, comment B, states the rule in like terms. The beneficiary may by a proper proceeding compel the trustee to render to the proper court an account of the administration of the trust. The trustee may be compelled to account not only by a beneficiary presently entitled to the payment of income or principal, but also by a beneficiary who may be or may be entitled to who will be or may be entitled to receive income or principal in the future. End quote from the restatement comment. Appellees argue that section 10.2 of the will relieves them from any obligation to account to a remainder beneficiary. This section allows the trustee to provide an accounting at any time, provided that if such accounting is approved in writing by the then income beneficiaries and the trustee is discharged with respect to the matters covered by the account. Appellees would have us apply this section to modify the common law obligation of a trustee to account. To our knowledge, no Maryland appellate decision has addressed the extent to which a decedent or testator may limit the common law duty of a trustee to account. This is the issue. To account in a court of equity, nor do we find any statute or rule addressing this point. In the present case, we need not decide this interesting issue because we do not interpret section 10.2 in light of the will as a whole to limit the trustee's obligation to account under the present circumstances. Interesting. Okay. And this is kind of the pertinent facts is from 10.02 of the will, which establishes the testamentary trust. So, when section 10.02, these are the circumstances, is considered in light of section 10.08, the former cannot reasonably be construed to deny appellant an accounting based on Harriet's consent to some prior accounting. Section 10.08 provides, notwithstanding any other provision hereunder, no trustee hereunder shall have a vote or otherwise participate in any decision regarding whether and to what extent any discretionary payment of principal or interest shall be made or allocated to or for such trustee's personal benefit or to or for the benefit of any person for whose support such trustee may be legally obligated. Any such decision shall be made by the co-trustee then serving, or if there is no such co-trustee, then the trustee shall appoint a co-trustee to make such decision. Merely if Harriet cannot participate in a decision to distribute principal to her, then her consent to such distribution cannot be considered binding upon a remainderman whose interest is adversely affected, since appellant's claim for accounting is based upon his contention that principal amounts are improperly distributed to Harriet. Section 10.02 of the will does not bar his suit. In sum, we hold that, yeah, I guess this is an equity principle. In sum, we hold that appellant was entitled to an accounting during the life of Harriet and at her death, notwithstanding the language in the will. So I could go into the notes and questions. One, how would Jacob have been decided under the UTC? It's not terribly long. Two, Section 603A of the UTC provides, while the trust is revocable and the settler has capacity to revoke the trust, rights of the beneficiaries are subject to the control of and duties of the trustee who are owed exclusively to the settler. After the settler of a revocable trust dies, do the beneficiaries have a right to information about the trust only as of the date the trust became irrevocable, or does the right to information reach back to earlier periods? Compare matter of Trimble from Iowa in 2013 only, which answers that question only as of the date the trust became irrevocable, with the estate of Geraldine in California, 2012. Beneficiaries of a formerly revocable trust have standing after the settler's death to assert a breach of fiduciary duty owed to the settler to the extent the breach harmed the beneficiaries. Duty to account is like a little subsection after this case and bringing us into the next case. Duty to account. Property fiduciaries such as executors, administrators, and trustees are required to file an accounting with the court prior to their discharge from office. For trustees, this will normally occur upon termination of the trust. For state representatives, the accounting occurs at the end of administration. In addition, the state representatives must make earlier periodic accountings beginning immediately upon their appointment. Many statutes also require trustees of testamentary trusts to make intermediate accountings, even where not required to do so. Trustees often find it advantageous to file periodic accountings with the supervising court as a means of gaining judicial approval of their actions with respect to trust property. Traditionally, the accounting takes the form of a detailed description of the fiduciary's actions during the period covered by the accounting. The accounting must describe property received, income earned, distributions made, taxes paid, and all distributions of income and or principal made during the covered period. Under the traditional rules, the fiduciary must provide notice of accounting to all persons having an interest in the estate or trust. Upon settlement of the final accounting, the fiduciary makes final distribution and is then discharged by the supervising court. Normally, beneficiaries have received proper notice of an accounting and failed to object. The fiduciary is protected against subsequent objections absent fraud. Of course, the case that follows illustrates the potential breadth of the term fraud.